Welcome back to this, the fourth and final part of the law of succession intestacy rules. We have more or less covered most of what you need to consider in rules relating to the law of intestacy. We have seen that the law's position for the most part has been to protect somewhat the spouse of the intestate, because the idea is that the statutory legacy will more or less allow the spouse to take the matrimonial home. So the family home, the spouse can remain in it even after the death of the intestate. We have also seen that the statutory framework has evolved over time to cover various aspects necessary to ensure that the law keeps in a certain fashion. So, for example, we see the rules have come on board to deal with illegitimate children, to look at the period of time after which the spouse has to survive the intestate in order to take. What we're going to focus on in this final segment is to look at where the law is going. What are the issues which are important as it relates to reform? Well, the starting point, of course, is that the December 2011 Law Commission recommendations, which have been put forward, published in December 2011, the Law Commission made certain recommendations for reform in its report entitled Intestacy and Family Provision Claims on Death, and it is Law Commission number 331. It is on the internet. I would urge you to look at it, because any sort of exam questions relating to intestacy, as far as an essay question goes, will certainly require some discussion of this Law Commission report. So it's Law Commission report number 331. And basically, there are several recommendations made in it, but what I'm going to highlight for you over these next few minutes are the main recommendations of the report as it relates to the law of intestacy, and they are as follows broadly. They are these. The first is where the deceased leaves a spouse but no children, the spouse should take the entire estate. We are going back to that same old chestnut. The idea again is that the spouse should just take the entire estate from the starting point. So at the end of the day, if you just have next of kin, it should be relevant. It should just go directly to the spouse. The next, of course, is that where there are also surviving children, the spouse should take the statutory legacy, all of the personal chattels, and half of the balance of the estate. Now, what is the current position? The current position, of course, is somewhat similar: statutory legacy, all personal chattels, and half of the balance of the estate. But currently, what we have is a life interest for the surviving spouse, and then the children get the life interest after the death of that surviving spouse, and the children would also get half absolutely in the meantime. So the current life interest arrangement would cease to exist. Here's an important one which I think absolutely makes sense. It's that personal chattels should be redefined. So if we look at section 55.110, the argument, or rather the recommendation being put forward by the Law Commission, is that a complete redefinition be considered. What they have said, of course, is that this redefinition would not have retrospective effect, which again makes sense because it could certainly raise a hornet's nest. So what it is saying is it should consider a redefinition to the extent that it means all of the deceased's tangible, movable property other than such property which consists of money or securities for money and was used solely or mainly for business purposes or was held solely as an investment. So it is requiring that the situation in respect of business purposes chattel go into the other part of the residue which is shared by the spouse and issue, for example. But the idea is that the fact that it has a specified list of what amounts to personal chattel arguably makes it far too tight, and therefore the courts have had to do too much of a gymnastic action in order to find that certain types of property falls by analogy to be personal chattel. And so, of course, it makes sense that this ought to change, of course. The surviving spouse's statutory legacy, it says, should be specified by the Lord Chancellor in statutory instruments. So, of course, statutory instruments from time to time would raise what the statutory legacy should be. And the suggestion here in the recommendation is that at intervals of no more than 5 years, the Chancellor should, of course, make some kind of statutory instrument to say what the increase might be. One significance, though, in respect of the proposal, and in my view, this is a little bit radical, and it is that cohabitants should have the same entitlement as a spouse. Now, I know I will get some feedback for this, but this is my view. This is Jennifer Housen's view. It is this: if you are not willing to be married and therefore be considered a spouse, why do you feel that you should get the same rights and entitlements as a spouse? I know that there will be those who will no doubt have something to say on that, and of course I look forward to that. But the idea, the recommendation is being put forward is that the entitlement currently extended to spouse should also be extended to cohabitants, and there is of course a limitation. It does say that provided the deceased was not married or in a civil partnership at the date of death, because certainly there are relationships where it is not a matter of the parties not wanting to get married. It's just that one party, for example, may currently be married to somebody else. Now, if that is the case, those people will not fall in what the recommendations are currently seeking to aim at. Now, this, of course, is subject to a requirement that the cohabitation lasted for at least 5 years. The problem with trying to take something out of a legal framework is that you then have to impose requirements and limitations and rules on them. And that is one of the concerns for me personally in a discussion like this, is that you are first saying that this must be met, there must be a 5-year, and then it goes on. It says alternatively, for 2 years, they should be in the relationship if the couple had a child together who was living in the same household at the date of the death. Now, again, we can see that there are advances in medical science, for example, and go back to the estate of Kay in Australia. What would this raise beyond what we currently have? What they have said happily, though, is that no reform is being considered necessary when one considers intestacy rules as they affect relatives other than the spouse and children. Now, what is the importance of that? Well, the only place where one could argue that there may possibly need to be change is that when you consider the specified relatives who can take, is there an argument to say that that should be widened, for example, before the crown becomes the last man standing, as it were? Should it be widened to third cousins twice removed, for example? The only change they're considering, obviously they don't appear to be great big fans of Harry Potter or something. They're deciding not to call people half-blood and full-blood anymore. What they're looking to do is to change the descriptions to full siblings and half-siblings. But further than that, they're not seeking to change anything in respect of that. Now, it is interesting that these recommendations have been put forward. It will be interesting to see how, if at all, they're taken on board in this area. Generally, we see that when these are raised, They may manifest themselves later on in a piece of legislation, but as I said to you earlier, I would urge you to ensure that you have a look at the recommendations themselves in full, because certainly if you are seeking to approach an exam essay question on intestacy, it is highly likely that the recommendations will be absolutely important. That takes us to the end of the intestacy discussions. What we will discuss next, in the next sessions of course, is we will start looking at wills.